SJC-12991, Kehle Osborne-Trussell v. Children's Hospital Corporation.
Okay, who do we have first?
That's me, Chief
Great.
Justice Budd. Good morning. I'm Michael Mason. I represent the plaintiff, Kehle Osborne-Trussell, in this case, and we're here asking the court to vacate the Superior Court's dismissal of the case. Here we made two claims under Chapter 149, Section 52E. And allowing the dismissal of this case to stand would really sanction conduct that statute was intended to prevent. It would also run afoul of the clear public policy here in the Commonwealth that protects victims of abuse who take steps to engage with the legal process and enforce their rights.
Attorney Mason, can you just say what your client did to show that she was trying to enforce rights under the statute?
Yes, thank you, Justice Budd. So a number of things. First of all, she had discussions directly with the hospital and explained the situation to them, telling them that she had the abuse prevention order, that she was enforcing it through the Haverhill Police Department, so that she was directly engaging with the police on it and pursuing it as a criminal matter, which actually did continue, Your Honor, after this case. It went through a criminal proceeding. But
did she ask for time off or anything like that?
What she didn't, simply because she didn't know when she was going to need the time off, Your Honor. That's one of the the issues in this case is that.
Did she raise the fact that she might need time off?
Well, she certainly gave them adequate notice under the statute, Your Honor. The statute includes providing a copy of a harassment prevention order as giving notice, which she did, and actually the hospital attached that to their papers. So she let them.
But she gave notice that she had an abuse prevention order. Is that the notice you're talking about?
Yes, Your Honor, and that she was enforcing it. So the hospital knew, and this is important really to both of our claims under the statute. They had notice that she was enforcing her rights, and the hospital also knew that she was likely to need leave in the future. They didn't know when precisely, but they knew that she was going to be engaged in the legal process, which could include meeting with the police, which could include going to court, and that's what was in the hospital's mind when they terminated her, really with no other reason to terminate her. And that's, looking at the analogous FMLA cases, they state that when an employer knows that an employee may need leave and they terminate them for that reason, that's retaliation, which here would be paragraph I of section 52E. So there's certainly enough that we pled here, Your Honor, to justify continuing with our claim of retaliation. And in terms of the interference provision under section 52E, that's paragraph H, there's no doubt that they had notice and that her termination prevented her from exercising her rights. She was attempting to exercise her rights, and she was fired before she could do it. And the analogy I drew in my papers, which I think is probably the closest when you look at the FMLA cases, would be a pregnancy situation. That in the Pareda case, for example, you have an employee who's pregnant. She doesn't know when she's going to need the leave. She knows she's going to be out at some point, hopefully doesn't know when that's going to happen. That's the situation my client was in. She was cooperating with the police. That process was ongoing, but she hadn't yet been, summoned to a court date. The police didn't need her to come in yet and give any testimony. So it was simply premature to expect her to give an exact date and exact duration of a leave.
Can I start, Chief Justice Budd, are you done? Sorry.
Yeah, go ahead.
Can I start with the employment itself for a second? Because there's something still remains to be done before she's a full employee, right? Have you alleged, I'm just trying to confirm that she is an employee based on your allegations, because even your allegations represent that there's some follow-up still going on, right? What is your understanding, at least what are you alleging based on why she's an employee, even though she's not completely done with the employment process?
Well, our allegations are, and thank you for the question, Justice Kopker. Our allegations are that she actually is an employee. I mean, this is someone who has gone through background checks. The hospital sent her an ID badge. They issued her an employee ID number. They put her on the schedule, told her when to show up for work. She's an employee. I mean,
But the letter that you both reference indicates she's still undergoing some kind of background review, right?
That's what the letter says, but with all due respect, that's just not true. I mean, she had gone through the background checks and then was hired. I mean, they
Was
put
she
her on the
getting paid
schedule.
yet? Was she entering time and getting paid?
She hadn't come in for her first day yet, Your Honor, but the nature of her relationship with the hospital was an employee. I mean, they hired her to be a staff nurse. As I said, she went through all the required background checks, was on the schedule. They told her to come in a week earlier. She would have come in that day. I mean, this is someone who's under their control and direction as an employee. So we certainly allege that she was an employee. And I would also point out, if there's a ruling in this case that someone who's been hired but just simply hasn't started work yet can lawfully be terminated because they've told the employer that they're enforcing a harassment prevention order, that would just create an enormous loophole in this law and completely frustrate its purposes.
What do we make of this sentence in the letter that says the work clearance process was not able to be initiated? That's your letter, right?
No, that's the hospital's letter.
Okay, what's your view? Is that incorrect then? The work clearance process was not able to be initiated?
Yeah, I mean, with due respect, Your Honor, I mean, it's completely false. I mean, it was completed. I mean, as I said, they put her through a background check. She passed it. They sent her an ID badge so she could get in the building. They told her when to show up.
She hasn't quite passed it, right? Because they're following, whether they should be following up on this or not is a separate question, but they are following up on this domestic violence incident, aren't they? They're both sides recognize, you say it was wrong for them to do it. They're going to tell us that it was right for them to do it, but they're still doing that before she's formally on the payroll, right?
Well, I mean, first of all, Your Honor, I think she was in their system because she had an ID number and was on the schedule.
So we should, in your view, because she's got an ID and she's been given this preliminary schedule, she's an employee for the purposes of a motion to dismiss. That's your essential holding on the first point.
Well, that plus it's the nature of their relationship, which is really what Judge Wilkins, I think, correctly focused on. She's not a volunteer at the hospital. She's not, an independent contractor. The nature of her relationship with the hospital is employment. So I think that's the overriding issue, and it's just supported by these other factors.
Okay, so let me get to the second part of this, because for you to win, we've got some gaps to fill, right? The statutory language isn't exactly satisfied. She hasn't earned leave or requested leave. Basically what she's doing is putting them on notice. I've got a problem with this other woman, and I want you to be aware of it because I got to deal with it, right? She's not requested leave. So we have to extend the statutory language to cover that situation, right?
Well, with due respect, Your Honor, I don't think that's correct because the statutory language.
Tell me how, again, we like to start with the language. Tell me how you meet the language exactly. I get that the legislature may have intended to cover this. It's just, I'm trying to make the language work in your favor here.
Yes, thank you, Your Honor. So, and again, there are we have two sections of the statute that we've filed claims under. So as to the anti-interference section, the FMLA, which, this statute, one reason I've drawn some analogies there is that this statute really mirrors the language of the FMLA in terms of, no interference, restraint, denial of an attempt, or sorry, exercising or attempt to exercise a right. It's really the same language. And under the FMLA, analyzing that same language, courts have found that if the employer has reasonably adequate information that an employee may require leave, that's enough. Once they know that there's a qualifying reason given, then the law protects the employee from being interfered with. And that's important. One of the sort of trade-offs in the law is that this notice really is intended to benefit the employer. And here they certainly had notice, reasonably adequate notice. And I would just point to the Shar case, the Sarnowski case, the Holiday case that we've cited in our brief at page 12.
Yeah, again, just help me with the statutory language a second. I get, you've done a really nice job on the analogy, and I understand that. I'm just trying to make the statute work in your favor. So use the language of the statute. Tell me how you meet the language of the statute.
Sure. Well, there's actually, on notice, I think this is even clearer than the FMLA, frankly, Your Honor, because this statute, paragraph E, says that the employer needs to get quote unquote appropriate notice. One of the issues here is that once my client told the hospital that she was enforcing this order, they didn't tell her what their policy was. And the statute says, well, the notice is according to the employer's policy. She didn't know what their policy was, but she told them directly that she was enforcing the order. So they certainly knew it. And she also gave a copy of the harassment prevention order, which is one of the enumerated methods of notice that the statute gives. So she actually specifically gave notice under the statute. I think that's the item number one is the order itself, and she gave that to them. So in terms of the,
I have the same concerns that Justice Kafka is asking about. This is a very difficult situation and very concerning that she wasn't hired or she was fired before she started. And maybe that speaks to whether or not in this circumstance she should be an at-will employee. But I have a hard time understanding what there is to suggest that Children's Hospital decided to fire her or not hire her because they were concerned that she would request leave. In fact, that's probably not why they did it. They probably did it because they had all of these concerns that were inappropriate, in my view, about harassment and domestic violence. But I don't think there's anything here that says, oh, we're going to not hire her because she might ask to go to court to renew her restraining order. I'm really having a hard time understanding that.
yeah, thank you, Your Honor. And that really gets to the claim we've made under paragraph I, which is the it uses the term discrimination. It's, really more of a retaliation claim. The case law under the FMLA reflects that once an employer has notice that the employee has a possible need for leave, that the employee is engaged in protected activity. And that's because when an employer terminates someone because they may need leave, and here they certainly knew that my client may need leave. I mean, she gave them the order and said she was enforcing it.
Counsel,
that's enough to show.
I don't mean to interrupt you, but I want to dovetail off of Justice Lowy's point. We're at the stage of 12B6. And so the issue that Justice Lowy just raised was, this is not the old Nader versus Citron standard. This is the Ianchino standard. This is, as your brother raised, this is more than notice pleading now. You've got to give us something much more to suggest that it's not just bald speculation that you gave notice, that you have this order, she gets terminated after well, arguably still in a conditional offer. So therefore, ipso facto, it's got to be because she was going to eventually ask for time off. Isn't that exactly what Ian Keno says you can't do? Aren't you just speculating here?
Well, Your Honor, we've actually pled the specific facts that would meet the prima facie case. So in terms of causation, we lay out the fact that she put them on notice. They said they were going to speak to the harasser, which, as we've argued in our brief, I won't go into that whole argument, but is completely improper. And then they let her go and gave her no reason. And when the case is analyzed under the burden shifting standard, once we've shown that the temporal proximity is very close, and here it's a week or less. I mean, we've cited cases where it's 11 months. Here it's a week. That's certainly sufficient to meet the prima facie case. And if you look at the broader circumstances, they gave her no reason why they let her go. What they've said, and they've attached their letter, is that they couldn't start the onboarding process, which is completely false. They didn't say, hey, we found disturbing information when we talked to your stalker. They didn't say that. They didn't say that you didn't meet the conditions of your conditional employment. So that argument they've made, I think, is a complete red herring. They said something completely false, which is we can't even start the process. I mean, she's at the end of the process already. So here, I think we've laid out the specific facts. We're not relying on just pure, conclusory statements that she could prove our case. I mean, this is at the pleading stage. We need to see how the evidence comes out. When you've got someone who's, actively pursued by the employer, passes a background check, they hire her, they put her on the schedule. She says, listen, I've got to enforce this harassment prevention order against the stalker. And then a few days later, they fire her. In the complaint, I'm not sure what else we could add that would give a plausible case.
Well, the point I'm making is that doesn't obviate Justice Lowy's point that they could have spoken to the defendant in the harassment order. They could have come to some other issue that was raised by that, other than potentially asking for time off to vindicate whatever rights she might have had under the 250 AD statute. It doesn't eliminate that.
First of all, Your Honor, it's actually a violation of the order for the stalker and the hospital to speak. The stalker is not to contact Ms. Osborne-Trussell directly or indirectly, including with an employer. So here you've got an employer actively, facilitating a violation of the order. I mean, the Peabody District Court already found that this person was a threat to my client and issued the order.
That can't be true, right, counsel? I mean, it can't be that the order as between these two individuals precludes children from doing something.
Right.
I mean, the stalker, first of all, the stalker is not allowed.
Right, I get that. I get the order. The order precludes the stalker from doing certain things, but it doesn't preclude children from doing things.
Well, I mean, I would argue that children's is facilitating a breach of the order. I mean, they have really no legitimate reason to talk to the stalker. That issue's been litigated. They did a background check on my client that came back completely clean. So there really is no legitimate reason for them to be speaking with the stalker at all. And again, I would note that if that was the reason they let her go, their letter would have said that, and it didn't say that. And I think we need the opportunity.
Would it be
litigate
permissible
this
for
case.
children? Would it be permissible for children to let her go because they learned, quote, the other side of the story?
No, I don't think it would be, Your Honor. I mean, that's already been litigated, and a judge found that the stalker was a threat to my client, and my client's enforcing the order. There's nothing that came up in a background check that would cause them not to hire her.
I didn't see this in the record, but could you, if you could point it out to me? Was the order at the point that it was communicated to Children's Hospital, was it only after the ex parte, or was it after a two-party hearing?
It was after a two-party hearing. It was almost a year after the order entered. So it was long after.
All right. And does it also indicate as to whether or not there was evidence taken from the defendant? Does the record indicate that?
It's a good, I believe that's part of the order, Your Honor, but I'm not entirely sure.
Okay.
Can I follow up on Justice George's question about the 12B6 standard? Because my understanding, your argument, and again, if I'm mischaracterizing, when she alerts Children's Hospital that there's a domestic violence restraining order out there. She is putting them on, I guess, what you call implicit notice that she may need time off to deal with this. Because again, I'm trying to apply the statutory language in a way that you win, but I need to get there. So I agree you satisfy everything except for the request for leave. You have to somehow get there. Is it that your notice that she's got this restraining order to children's means that she's implicitly said, look, I'm going to need time to deal with this? And is that enough for you to satisfy the 12B6 standard? Because, and is that right? Is that your argument?
It is, Your Honor. And you know, the issue with that claim, the retaliation claim under paragraph I.
I get I. If you've met the I you meet, if they fired her because you requested leave to deal with this, they're violating I get it. But I've got to somehow get over the hurdle that the trial judge or the motion judge didn't, which is that you requested leave. And I'm trying to get a sense is your notifying them an implicit request that you're going to need time to deal with this through your work? Because we have to get over that hurdle, don't we?
Well, yes. I mean, we need to allege enough to show that there's a plausible case that they fired her because she engaged in protected activity.
Right.
And that's where these FMLA cases are helpful because, and I can point, I think this is probably the best distillation of this point that I could find, Your Honor. It's in a case, it's not in my brief. I'm happy to send the site over today if that would help. But, you know, in a case, it's called Johnson v. Dollar General. It's out of the Northern District of Iowa. And the court there said that it would defeat the purpose of the statute to allow an employer to retaliate against an employee when the employer has received enough information to put the employer on notice that the employee may need FMLA leave. And the reason for that, the court explained, was because in that situation, the employer has both shown the required animus and engaged in conduct of sufficient gravity to brand the employer's actions as retaliatory. So, you know, under the interference provision, there's no motive that we need to prove. But even under retaliation, you know, once they know that she may require leave, and again, I think we've put forward more than sufficient facts to show that they knew that, they can't fire her for that reason.
But counsel, and I don't want to belabor this point, but there are a whole lot of dominoes that would have had to have fallen for all of this to come into play. You allege a violation. Some reviewing authority was going to have to find, either by an application or the police, probable cause for a complaint. There would have gone, you know, through all the procedural machinations, assuming all of that, and then potentially a trial. There are all of these things that are so far downstream, which again goes back to the Iankino standard. You're making a lot of presumptions here that needs to be alleged with some specificity, with some heft in the complaint. And I'm just wondering if you're saying it's there, then that's all you need to say. But again, I'm just wondering, I didn't see that in there, and I'm wondering if you're saying that that's pled in the complaint, and if you could point me to where that is.
Well, Your Honor, you know, my client those things hadn't been scheduled yet, Your Honor. And I think the issue here is that, you know, if employers are allowed to fire an employee who comes to them, which is what the law encourages, is this notice, and that's for the employer's benefit. If an employee comes to them and says, you know, I'm in the process of enforcing this order, I've been in contact with the Haverhill Police Department, here's a copy of the order, and then the employer can fire that person with no possible consequence, I just think that completely upends the purpose of this law and also violates public policy, as we've alleged in our complaint. So I absolutely think, and we've alleged all that, and I think that's certainly sufficient to state a plausible claim. I don't think the law says that an employer can fire someone when they know they're enforcing their rights, as long as no actual court date or no actual police interview has been scheduled yet. I mean, that's just not what the law intends or is addresses. So I do think that we've certainly pled enough to state a claim under those two different provisions of the statute, and also under the public policy claim, which, I don't know if the court has any questions on that issue. I think we've addressed it in our brief, so I'm happy to rest on that if there are no questions.
Okay, thank you, Attorney Mason. Attorney Riley. You're on mute.
Good morning again, Chief Justice Butt, and may it please the court. My name is Richard Riley. I represent Children's Hospital in this matter. With me in the virtual courtroom, but socially acceptable 6 feet away, is Peter Kober, the attorney who was with me on the brief, was indispensable in the drafting of that brief. I would like to raise first the issue of whether or not Ms. Osborne-Trussell qualified as an employee under the statute. Judge Wilkins held that she did qualify for reasons stated in his opinion. Respectfully, we disagree, and because this court can uphold the dismissal of the case on any basis that's available to it in the record, we feel this threshold issue is the first to be discussed.
I'm not aware of employees who get badges and a work schedule who haven't been cleared for takeoff. Is that a common practice at Children's Hospital? I mean, getting a badge at a hospital is a big deal, isn't it?
It is, I'm sure, Your Honor, as soon as it's, activated, whenever that is, to actually open doors and whatever that may entail. But the offer letter stated not just that our offer is contingent upon a comprehensive background check, it stated that employment is contingent upon a number of things, including a comprehensive background check. The timing that is available in the pleadings that we can derive from the pleadings alone is that the offer letter was made on February 12th of 2019. And it was on February 28th, 2019 that Ms. Osborne-Trussell discovered that the alleged harasser had contacted the hospital and violated the HPO and brought this to the hospital's attention. So regardless of whether the background check, to the extent it had been done prior to February 12th, had been completed, it was certainly within the hospital's purview, and I would suggest the obligation of an entity such as Children's Hospital, and considering the population of patients and families that they serve, that if they receive information such as is alleged in this case from a person allegedly harassing this prospective employee or the person who has accepted the offer of employment contingent on the background check, that they continue the background check. And that they did continue that is evidenced by the fact that, as is alleged in the complaint, the plaintiff, the hospital informed the plaintiff in response to the post-February 28th interaction, informed the plaintiff that the hospital was going to communicate with the alleged harasser to get her side of the story. That's what the complaint alleges, which understanding that we're bound by that. I know that I'm not, it's not open to me, nor would I attempt to present to the court any actual facts as might be elicited in the course of the case.
But again, from a 12b6 perspective, don't we have enough facts alleged that she was essentially hired and she was fired based on your investigation of this harassment prevention order, which a court had issued? Don't we, again, trials are different matters, even summary judgment after discovery, but
Sure.
They've alleged essentially you gave her a badge, you put her in a work schedule, she informs you that she's got someone stalking her, and then you fire her after you follow up. There's no indication of anything else in this except for that. And doesn't that get you, I want to get to the leave issue separately, but doesn't that, I think they seem to have alleged enough for her to be an employee and that you fired her because of this.
We respectfully disagree.
Give me something in their allegations that support that that's not the case. Because again, we
Yes.
accept everything they've alleged is true.
Well, all of the
And the reasonable probably inferences that you can draw from that.
correct. And what they have alleged in terms of the connection between, well, we haven't gotten to whether or not a request for leave was made, but whether or not any effort to restrain or interfere with Ms. Osborne's asserted rights under the statute was the reason that the offer was withdrawn or the employment terminated. That's, that for this point is that's not important. The only allegation in the complaint is essentially what in the case law has been referred to as temporal proximity. The case law is pretty clear that temporal proximity is not enough. We argued in the brief,
We got more than temporal proximity. We also have that she had a badge, she was scheduled for work, and that you told her you're going to follow up on this. So, it's
Correct.
not, we got a lot here, and this is a 12B6.
right. But what is not said, other than the temporal proximity, and what you just suggested, Your Honor, is that there is a temporal relationship after the hospital said we're going to follow up and communicate with the harasser, that the offer was withdrawn. The fact that that was the sequence of events does not establish, and it's not sufficient to plead only the temporal proximity. There was no allegation in the complaint that there was any comment made to Ms. Osborne-Trussell, whether it be in the form of a criticism or as was stated.
I think I get your, let me move to the second point, which makes me nervous from both sides. So domestic violence is not something like a doctor's appointment you can schedule. It happens, your partner attacks you, you've got to run to court. And you got to do it quickly, or we can't plan domestic violence. It's not. So isn't this enough here? If she were an employee, I understand your first argument, but if she's employed and she says, this person just violated this order, I've got to respond to this immediately. She doesn't know when she's going to run, she's got to get a lawyer, she's got to do other things. I mean, isn't it, we can't plan these things. This is just, again, it's not like going to the doctor and getting your, arm looked at.
Mm-hmm.
It's an unplanned, unprovoked attack that she's saying, I've got to deal with this. And by the way, she alerted you, it's not like she just, you were on the Facebook notice, right?
It was actually an email, I believe, Your Honor, but there was a posting that was tagged, yes, to the hospital. So
isn't that enough? She's saying, look, you're my employer. I got to deal with this. And as a courtesy, she's letting you know too, because, she could just do nothing too. I'm just trying to figure out why that's not enough for notice here, even under this statute, which talks about a request for leave.
Sure. Well, the statute actually, first of all, Your Honor, I want to make one point clear, which may drive towards the public policy issue. This is not a domestic violence case.
Right.
There's no domestic violence involved. There's no domestic aspect to it at all. This was a harassment prevention order against a third party unrelated to the plaintiff who she claimed was stalking her.
Right.
So in that context, but nonetheless, the notice provision in section 52E contemplates.
Again, I'm not sure stalkers plan their attacks either.
No.
I mean, I'm not sure we can count on a stalking incident the same way we can plan on a medical appointment.
I no, it did not intend to for that to be the point, Your Honor. The section 52E specifically contemplates the possibility of For instance, under Section D, a threat of imminent danger, in which case the notice requirement is not, the employee does not have to comply with the notice requirement and can satisfy it with giving the necessary information about it after the fact, which goes to the point of this statute contains requirements and it contains limitations as to who it covers, when, and under what circumstances. We're past whether she's an employee. I think that, you know, our argument is made on that in the briefs and in the discussion we've had here just now. But as far as notice is concerned, the notice is that I need leave. The notice is not that I may at some unspecified point in the future need leave. If that were the case, then an employee who had any kind of a dispute that warranted a harassment prevention order could tell the employer that on day one or in the interview process, and then from day one forward, that employee would essentially no longer be an at-will employee. Because if that employee were terminated for no reason, which is what an at-will employee is, then the same argument is being made here could be made. Well, I told them that I might need leave under the abusive behavior statute at some point in time, and they fired me after that, so therefore there's been a violation of the statute. There was no actual request for leave. In fact, in the reply brief of the plaintiff, it is admitted that the reason that no amendment to the complaint in the underlying matter, which Judge Wilkins invited the plaintiff to do, the reason that no amended complaint was filed was because there were no additional facts to allege. This is on, I think, page 6 of the appellant's reply brief.
Counsel, can I ask you to address your brother's point that by giving the hospital notice of the HPO, it was sufficient, as it might be under the Family Medical Leave Act, to put the hospital on notice that leave may be required if it, you know, if the court date interfered with the schedule, if all these contingencies happened, you know, if I go into premature labor. And why isn't this enough?
Simply because, Your Honor, this particular statute, not the FMLA, I'll get to that, does not speak to protection of employees who might someday need the protections of the statute.
No, but I'm talking about notice. Like, why isn't it enough for notice to say, here's the HPO, this posting happened, I'm pursuing police action? Why isn't that enough notice of the leave that may be required? At this point, she doesn't know if the court date's going to interfere with whatever schedule the hospital has planned for her.
Sure. Well, eventually she will, presumably. It might be the same day, it might be the next day, but she will know if there's going to be a hearing or some meeting with the DA that she needs to attend. And at that point, she will give, as required under the statute, the notice. And again, if there's imminent danger, the notice provision is amended. The FMLA is a very different statute in terms of the notice that's required. The amount of time that it provides the employee and the disruption to the employer's work are completely different, such that the Congress delegated to the Secretary of Labor the right to draft regulations. And one of those specific regulations is 29 CFR 825.302, which is employee notice requirements for foreseeable FMLA leave. That section, which is discussed in the amicus briefs as well, does require an employer, even if the employee doesn't quite know that it's FMLA they're looking for and isn't entirely clear as to what they need or when they may need it, there's a requirement under this regulation, which is 2.5 single-space pages long, that the employer has to engage in a proactive discussion with the employee and try and figure out what you're going to need, when you're going to need it. That is not what the abusive behavior statute in Massachusetts is about. It's very specific as to the rights that it confers and it's very specific about the limitations as to the companies that are subject to it, not including any who have fewer than 50 employees. The requirements of notice and documentation to establish what leave is required, to establish it's one of the purposes set forth in the statute, when it's going to be required, et cetera. So the FMLA cases are really, on the notice issue, are not analogous at all. They serve a different purpose and are the subject of detailed regulation, which itself shows that if our legislature had intended anything other than what it states in the statute, it could have said so. Do you think our legislature intended,
so I'm not saying this is exactly your case, but let me posit the following hypothetical. Some employee comes in completely upset. My spouse is beating me, and your employer says, you're fired. I take it your view is that's okay.
No, you're
why isn't that okay?
Well,
your view.
The Chacon case says that temporal proximity is not enough. Frankly, I think that if in the meeting and to the face of the employee in response to that statement, that rule might be bent or.
Why is it different than what you're arguing? I'm just not sure I understand why it's not, because essentially you're saying if you fire them before they requested, you're safe. But I just distinguish that for me, because I'd like to have comfort that I'm not allowing that to occur if I decide in your favor.
Well, safe is, I'm not sure the word I would use. The employer we start off this whole analysis with the employment relationship being at will. Unless there is some statutory violation or a public policy issue, which we have not yet discussed, there is no necessity for giving the employee a reason. The hypothetical that you have just suggested, which are not the facts of this case and are not pleaded in this case, I would, if I were representing the plaintiff in that case, I would argue that temporal proximity, which is bing, directly in response to one statement that you're fired, it's implied you're fired because you just told me that you had to go to court to get a restraining order. In our case, there is nothing but a temporal proximity that is somewhere in the course of about 2 weeks, during which other things were happening. The thing that was happening was the communication with the alleged harasser. A question raised earlier, which it highlights the issue, although it's a danger area, and I'm not suggesting in any way this is what Children's did or would do. But if Children's had contacted the alleged harasser and learned of facts that convinced it that, my goodness, there is really a lot more to this story, and we have some significant doubts about this current almost employee and her maturity, her judgment, her character.
Isn't that for summary judgment and trial? You may have discovered that she was stalking the other person, and you can't have someone like that working in your hospital, or the two of them are going to draw swords in the middle of the emergency room.
Mm-hmm.
But we don't have those facts.
We don't.
That's for summary judgment in a trial. What we have are close temporal proximity, no other explanation, and a statute that isn't clear, but I just.
Well, Your Honor, if I may, what we don't have is really anything more than temporal proximity, because it's not as if there's no other explanation. It could be, and I say could be, knowing this is speculative, and I'm leaving it as speculative because of where we are in the 12b-6. It is just as likely, if not more, that the hospital learned something in that ongoing background check that is focusing on the alleged harasser and the communications it was receiving.
That's for trial or
I
summary.
understand, Your Honor, but my point is that if you take that out of it, that speculative possibility is there, but the plaintiff has alleged nothing more than the speculative possibility that the action taken was in an effort to deny her leave rights under the statute. So you have to plead more than speculative, conclusory allegations. There has to be something specific. And I point back to the Chacon case, which talks about why temporal proximity is not enough in a situation, an FMLA case, and why it's not sufficient is because there were nothing like, and this court gave the examples of negative comments by a supervisor, expressions of reluctance about that employee's history of FMLA leave taking, something that is more than temporal proximity that would suffice to establish, if proven, that there was a connection between, not just between learning about the harassment prevention order, but a connection between the withdrawal of the offer or terminating her, whichever the court ends up deciding it is, and a desire to interfere with the employee's rights under the statute, the right to leave. And my suggestion is that the complaint as it is leaves it as speculative that that was the reason, as it would be speculative for me to say there were other reasons discovered in the course of the background check. It's the plaintiff's burden to allege more than speculation, and that's what was not done here. So the complaint is insufficient in that it does not establish that she was an employee. It doesn't state that she requested leave or that leave was denied or interfered with or that she was retaliated against any right that she had under the statute. The public policy issue, if I could briefly address that, the public policy is a kind of an escape hatch where there is no other recourse available to an individual. The recourse in the Apesos case, for instance, there was no abusive behavior prevention act at that time. And so therefore, I think it was Judge Sikora ruled that there was going to be a public policy reason to recognize that right. But we now have it. Since 2014, we have a very specific statute that covers the landscape in terms of what the legislature believed needed to be provided to employees and the limitations on it. The best example being it doesn't apply to companies that employ fewer than 50 people. That's a policy determination that the legislature made, presumably after considering the host of factors that would go to this, the burden on the employer, the need of the employee, fairness in terms of notice and substituting employees for the absent employee. All those things are fodder for a legislative action and not for a public policy determination by this court, particularly where this is not a domestic violence issue. This is simply a harassment prevention order that under the statute, under the stalking statute, actually, what's required is, I don't have the wording right in front of me, but it's just a pattern of behavior that is directed at a specific individual and designed to cause them mental distress or fear or anxiety. Words to that effect. That public policy, I mean, there's a statute that prohibits it. In fact, makes it criminal under certain circumstances, but it's not domestic violence. So, you know, this case is not the case for this court to determine that it is incumbent upon the court to establish a public policy exception to the at-will employment doctrine because this is not that case. It may
Okay. All right.
case.
Thank you. That's been very helpful.
Thank you
And
for the
we're gonna take a 5-minute break at this time. Thank you.
Appreciate it. Thank you, Ernest.